The Swaziland Electricity Company says an employer or employer does have the right to dismiss an employee who has been found guilty of gross negligence. SEC said this in the High Court through its lawyer, Advocate Paul Kennedy, during the hearing of its agent appeal when they wanted the court to set aside a decision of the Industrial Court that compels SEC to reinstate 4 employees who were fired for gross negligence at work. We have a report.
The Swaziland Electricity Company has filed an urgent application at the High Court where they want the court to review and set aside a decision of the Industrial Court to have 4 employees of SEC reinstated. According to court papers filed by the applicant in court, there were employees under the maintenance section who were working on some power lines when suddenly some other employees switched on some electrical installations that they were working on, which resulted on 4 employees being electrocuted to death while some were severely injured. The 4 employees, Swambongsen Dlamini, Tinamaseko and Tabiso Dlamini, were charged with gross negligence, while Simon Dlamini was charged with dishonesty with some elements of fraud. The matter was deferred to a disciplinary hearing, which found the respondents guilty, and the chairperson of the disciplinary hearings returned the sanction of final written warning in each instance. The sanctions were to the effect that some employees had to work for 3 months without pay. Following the verdicts of guilt on the sanctions of final written warnings, SEC, in particular the General Manager Operations, was concerned about the apparent leniency of the sanctions and the implications to the applicant of returning the respondents given the gravity of the offences for which they had been found guilty. Having taken advice on the matter, and in particular the remedies available to SEC in the event she was dissatisfied with the outcome of the disciplinary hearings, SEC then issued a notice to the employees calling upon them to show cause why SEC should not intervene and interfere with the disciplinary sanction by substituting the sanction of a final written warning with that of dismissal. The employees objected to SEC's right to intervene and interfere with the disciplinary sanction. The employees' services were indeed terminated, and they ran to the Industrial Court for a review of that decision. Industrial Court Judge Ngosinati Ngonyane presided over the matter, and he ruled in favor of the employees. He issued an order that they should be reinstated. SEC duly complied with that order, but that didn't mean the matter was over, as she approached the High Court seeking an order to review and set aside the Industrial Court's decision. When the matter appeared in the High Court before Justice Tinsile Mabuza, SEC was represented by SA Advocate Paul Kennedy, while Siboniso Hlope appeared on behalf of the respondents. Advocate Kennedy informed the court that an employer does have the right to substitute the decision of the chairperson of a disciplinary hearing in appropriate circumstances, though. He said gross negligence is a dismissal offense according to labor laws. Kennedy further submitted in court that the Industrial Court lacked jurisdiction in the matter because the employees should have approached CIMAC as per the dictates of the Industrial Act. Hlope, in his argument, informed the court that SEC took time to review the decision of the chairperson of the disciplinary hearing, which the Industrial Court also found. Hlope did admit that the employees were negligent, but he said SEC should have followed laid-down procedures to discipline them. Hlope informed the court that SEC wrote to the employees informing them that he was happy with how the hearings were conducted, but she was concerned with the sanctions. But she then went outside the guidelines and dismissed them. He informed the court that should SEC be allowed to continue with her hire and fire phenomenon, it would be detrimental to the employees. He said the Industrial Court had jurisdiction over the matter because SEC acted outside operation guidelines between the employer and the employees, yet she had a right to approach the courts in an event she was not pleased with the decision of the chairperson of the disciplinary hearings. He submitted in court that the application should be dismissed with cost. Judge Tinsile Mabuza is yet to issue his verdict on the matter. For Swazi TV News, I'm Linton Gule at the High Court.